Greetings to everyone who's watching. In this video, we share some of our experience in the field of litigation and arbitration in civil and commercial matters. We'll discuss the length of our experience and its depth, analyze some results of our work, and we offer some of our observations about the flavor of this practice area. This video may serve as a short insight into what can be expected if our expertise were sought in these matters. And today we're joined by our colleague Andres Eglitis, with whom we have worked for years in this area. As always, Andres, welcome to this discussion.
Hi there, Mars. Great to be here.
So let me fire away with the first item. We have experience in commercial litigation and arbitration since 2002. And why this year in particular? Because that's the year when I finished my master's degree at the University of Cambridge, where I was studying international commercial litigation as well. And I jumped into this practice area right after my studies. So more than 20 years of experience with all sorts of courts and cases in this area. So it goes without saying that we've been to all levels of the court system in Latvia in these more than 20 years. But I believe it's probably more interesting to discuss our work internationally. We have been to the Court of Human Rights in Strasbourg, the European Court of Human Rights. We've also been involved in proceedings before the Court of Justice of the European Union, arbitration in Vienna, and also proceedings in London, in the High Court of Justice of England and Wales. So we could probably discuss shortly our involvement. For example, in the Court of Human Rights in Strasbourg. That followed from a rather peculiar case in Latvia, the so-called protest case, when we still had some remnants from the Soviet era in Latvian law, when the chairman of the Supreme Court could actually file a protest against the ruling made by a court of first instance. And then a panel of judges would come together in the Supreme Court and decide whether to reverse that or annul that or not. This is something peculiar, wouldn't you find? That we still...
I totally agree. And from our perspective and from our point of view, we saw this as a major issue straight away. But I do recall that an opposing counsel basically argued, oh, this tool, it has existed for 30 years. And what has suddenly changed? It's great. It's fantastic. Yes. But so the problem was that it might have been fantastic in Soviet times, where the system could not tolerate some certain outcomes in the court, and so there ought to be some kind of ways how to reverse the wrong judgments, which were considered as such by the government or the legal community in itself. But that's not the principle which stands in civilized Western world. So that's
exactly a peculiar case.
Yes.
But ultimately, I think that the Latvian government, they were ordered to pay some 5,000 euros or something. But that brings back good memories. And the opposing arguments were indeed, we've had this system for years and years, and what has suddenly changed. It's actually astonishing that nobody before us had tried it. And indeed, these protests were being filed, and the system was up and running. So sometimes it can be surprising. And then the proceedings before the Court of Justice of the European Union, that followed from a receivership order that came from the court in London. Yes, and we opposed it. And ultimately, there was a reference for a preliminary ruling, and then we made observations and submitted our vision how things should be happening. But that was an interesting beast, I have to say. These receivership orders from England. That's something we do not really have something similar in Latvia, do we?
No, we don't. We didn't have. Didn't have. We had not had at the time, and so that's the in general the principle of that's the English law is a bit different legal system in general, and the main issue obviously was how do um, orders and injunctions issued by courts in England, how are they to be understood and enforced in other member states of European Union?
Basically,
Which
how
was,
to reconcile them,
yeah,
how to reconcile. Well, that was
what
an
is
interesting case as well. And then the
yes.
next one, arbitration in Vienna. Two banks were wrestling in arbitration in Vienna, and then we helped with Latvian law, with the Latvian case law that became relevant in that jurisdiction. And then again, London, same court, High Court of Justice of England and Wales. We were in a supporting role. I believe I even made an affidavit, a long affidavit on Latvian law that was submitted there. So I suppose we could say that we have a pretty good understanding how the system works in Latvia and how it works internationally, having been involved in all these proceedings for many years.
I would agree. And well, the point about what all transcends all these cases is that there is a Latvian law issue, but then it's another element of international law or jurisdiction or party abroad. And then the main issue is how you put it all together and make it work in a proper manner. And that
Yes.
might be challenging in Latvia, as we have experienced, that this is something that does not come lightly to Latvian courts and Latvian
Oh
institutions
yes,
in general.
I would agree. So shall we move to the next item, which is some results of our work? And I've put in two examples. The so-called parallel shareholders meetings, and what does it mean to vote against a shareholders resolution at a meeting of shareholders? The first one, the so-called parallel shareholders meetings. There have been nasty disputes in this area. Basically, what happened was that there were two groups of shareholders who were fighting each other, and each group held their own shareholders meetings, and then both groups would bring their paperwork for registration to the Latvian Register of Enterprises. And what happened was that the first one, the group that was faster, they got registered, and the other one would not be registered. And these parallel shareholders meetings would somehow block each other out so that nobody would be registered. And the ones who got registered first, they would remain registered. And this was a deadlock because obviously shareholders meetings were taking place, and we had to do something about it. So what we did, we went to civil courts, but we also litigated against the Register of Enterprises, against this practice that the shareholders' meetings block each other out, even though we didn't find anything like that written in our law. And ultimately, the court of first instance said, no, the Register of Enterprises is right. On appeal, the same, they are right. And then ultimately, someone at the Supreme Court finally started analyzing this issue. But hang on, wait a second. Why are these two shareholders' meetings blocking each other out? Why are you not registering the first one and then the second one and basically do it almost every day? If a package of documents is brought to you every day, why don't you register both of them every day, even with a difference of 10 minutes or 20 minutes or 30 minutes or whatever? So what do you think about that case? It was a long dispute. It was a long fight.
It was a very long dispute. It was a hard dispute, I would say. And what I do recall is that the law actually clearly stated that the documents which are submitted to the commercial register are ought to be reviewed in the order how they are submitted. So technically speaking, the solution which the Supreme Court finally upheld was actually the law, which was clearly and was precisely written in already in the and provided for in the law. And the concept that was created by the Register of Enterprises was something very puzzling and well, obviously, as the court's rule did not comply with the requirements of the applicable law. So that was a hard and hard fight and a long fight, but eventually
It took
yes.
it took the Supreme Court to reach this conclusion.
Yes.
It's somewhat surprising that the Court of First Instance or the Court of Appeal did not reach this conclusion. But okay, all right. The next example that I put in, what does it mean to vote against a shareholder's resolution? And that's the case that where you've been involved in these proceedings. You appeared before the courts. And what was happening, you'd have a shareholders meeting, you represent a minority shareholder, as you did at that shareholders meeting, and you voted against a certain resolution. And we started litigating about various aspects, about the protection of minority shareholders, about the auditor's work and all that. But this particular issue, we reached the proceedings reached the Court of Appeal. And then somehow, surprisingly, in their judgment, we read something completely unexpected. At least for me, that was shocking. What the court said, in order to come to court, in order to file your claim, it is not enough that you vote against a resolution at this shareholders meeting. You need to have this documented in the meeting minutes, and that's not enough as well. Not only documented, but you immediately have to give your legal reasons at the shareholders meeting. Why are you voting against? So basically, you need to refer to law. You need to explain your position legally, almost as if shareholders need to go to shareholders meeting with lawyers and have their statement of claim already prepared. And if you have all these things documented, which is not an easy thing to achieve, I have to say, because as a minority shareholder, you have no say over who's preparing the meeting minutes. Would it be documented in the meeting minutes? So a mission impossible, I would say. And this comes from the Court of Appeal. So we filed a complaint of cassation. And luckily, happily, the Supreme Court said this is all nonsense. But then again, this came from the level of the Court of Appeal. And these people are still in office as if nothing had happened. Sometimes these situations really puzzle me, how this is possible. Nothing of this was written in the law. This was just of the court's own initiative that you need to achieve this level of documentation to go to court. What do you think about that one?
Well, I found that ruling very surprising because for many years, shareholder disputes was on the agenda of the courts. So there was a pretty well-established framework as to what ought to be done and that what are the requirements to file a claim, which basically were pretty straightforward and did not provide for any such requirements as you just explained. And on top of that, that was the basically Court of Appeals or the Court of Second Instance when they were reviewing the claim. And this basically came as something from the court, even though it was not raised and argued by the parties. It was a complete
that's my recollection as well.
Rise of new kind of requirements or new kind of legal tests that ought to be observed, where there is clear indication that no such provisions or requirements have been written in the law or even discussed in any kind of legal doctrine. So that was completely something shocking, and came to the point was like, how are any party ought to know that these are the rules that the party should follow, when the first time you hear about them is in the ruling of the Court of Appeals. That was just
Exactly.
astonishing.
And this actually brings me to the next item, the flavor of the judicial system in Latvia. Looking back at all these 20 plus years, well, let me say what this flavor is for me. Some years and years ago, we had a system where a peculiar judgment from the court of first instance would be subject to appeal. You pay a reasonable stamp duty, you go to appeal, and if this is not remedied, you are almost guaranteed access to the Supreme Court. Okay, probably people made such a mistake as they would not explain the case properly or something like that, or they would just say that the Court of Appeal is wrong without giving reasons and explaining how exactly the court is wrong. If you made such an error, then okay, you wouldn't be heard by the Supreme Court. But in other cases, you would be heard by the Supreme Court, and that was a very decent guarantee that the injustice would be remedied. But we're no longer there. Now, practically everything seems to be decided by the Court of First Instance. On many occasions, the Court of Appeal simply concurs or agrees with the findings of the Court of First Instance, and then you get lucky if you are heard by the Supreme Court. This is no longer guaranteed. They really must see something in the case. And what's the legal rule? What's the test? The test is if they say that there's nothing obviously wrong with the judgment of the Court of Appeal, and this case is not important for making case law, then they can refuse to look into this. And then you're stuck with the ruling of the Court of Appeal. And we've just discussed what you can sometimes expect from the Court of Appeal. As we've just discussed, what does it mean to vote against a shareholders' resolution? These things keep happening, and if you're not guaranteed access to the Supreme Court, you could get into trouble. And so, for me, this flavor is getting slightly bitter than before. So, what is your impression? What do you think?
Well, I think I would agree with the way how you describe the situation. I can, again, looking back to our experience, where we had the proper three level court system, and the cases that we argued that on many cases that basically you'd have to go to the Supreme Court to basically start to seize the legal issue at the hand, or what is the core legal issue. And then the Court of First Instance and the Court of Appeals on the first case, in many occasions, simply neglected or didn't even address the points that were argued on the point of law. And obviously, we have had a ton of cases where the case has been thrown back to the Court of Appeals, and then Court of Appeals again fails to apply law properly, even after the Supreme Court has given an indication of interpretation on the law. So, from pure experience, such system was required and it was necessary to basically properly deal with the legal issues. And even though it was lengthy, it would take more time. But if the courts err, then what do you do? Do you just simply
Look at these,
say that
look
you
at
have
these
to work on?
certainty issues. These certainty issues. What does it mean to vote against? We couldn't imagine in our wildest dreams that a ruling like that would come out. This is just impossible to predict. And it's for me. I miss the old system. I really miss it. And we've tried doing something about it. We've gone to the Constitutional Court. We've challenged this system. We've challenged the law implementing the system, and the Constitutional Court said, no, this is well within the powers of the state to impose a system of civil procedure that the state wants. And okay, I agree that the Court of Human Rights in Strasbourg, the European Court of Human Rights, they have ruled that you're not really entitled by international standards to have three levels in the court system. Okay, you're not entitled. You need to have at least one. So I've heard arguments saying you're lucky that you still have three instances, three levels of the court system. It would suffice for the state to just impose you one. But again, I miss the old system. I miss it. I think it was more appropriate to reach a just solution. So
I would agree. The court of first instance, I think it's also a matter of how thoroughly the court of first instance actually deals with the case. And it's historically has been the case in Latvia that well, since you have a court of appeals, then you can try to remedy and then address various issues at a later stage. And that's not obviously the case how it is being handled abroad. And so there is some kind of issue there that's basically there is a change, but it does not properly affect how the case is treated and the court of first instance and the court of appeals. And effectively, this change that beforehand, as a party, you had the right to go to the Supreme Court and that case would be reviewed. Now it has been changed that it is the right of the court to decide whether your case will be heard. And
I know they have this system in America, in England, elsewhere, but I think we were just not quite there yet to copy it fully. I think we were not just quite there yet. So would you say it would be a fair observation to say that litigation can be a long and bumpy road, potentially full of all kinds of surprises?
Well, at least from our experience, that it not only can, it usually is. And I think we rarely had any kind of examples where everything went fast, smooth, and just as any party would expect.
There's always something, isn't it? There's always something comes out. There's always, you think you've analyzed everything and you expect a certain outcome, and that's why you go to court and you expect analysis and you expect just just straightforward application of law. But there is always something always comes out, and this is happening every year. I remember when I was a student at the University of Latvia, we were told that okay, a couple more years and everything would be as in Germany. But I think we're not quite there yet, and it's been more than 20 years since I graduated from that university, and unfortunately, perhaps it's time to go back to the professors and say, 20 years have come and gone, and we still see something which we saw quite some time ago. Wouldn't you say?
I would agree. Yes. Unfortunately, that is at least how I perceive the courts and in general legal system in Latvia. You can never basically, even in your wildest dreams, guess what kind of surprise awaits you. And that's also why you should actually use proper legal support, because even in straightforward cases where you think that everything is clear cut, you're suddenly faced with issues that nobody could basically come up in the world. And then you are left in a situation that you have to deal with that. and it's not always clear or straight away understood how to even address that.
Indeed. Well, we can say thank you to everyone who's been watching. If you get into trouble, then if you seek legal assistance, we're here. So thank you, and until next time.